for this hearing. Justices of the Constitutional Court or Council are online. I call the matter of Eskom Holdings SOC Limited and Vaal River Development Association, Pty Limited and others, and Eskom Holdings SOC Limited and Lekwa Ratepayers Association, NPC and others for hearing. Council are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you, Ms. Mbali. Yes, Mr. Shangisa.
Thank you, Justice Madlanga and the justices. Together with Ms. Lebohang Rakhwale, I appear for Eskom, the applicant in this matter.
Thank you, Mr. Shangisa.
I please the court, Mr. Weinberg and I appear on behalf of the respective first respondents.
Thank you, Mr. Van Eeden. Council, I continue to experience the same problem you saw when I met you at 9:30. I'll be invisible. Please, Mr. Shangisa.
Justice Madlanga, before Mr. Shangisa starts, please can you inquire from counsel if we should admit Nontokozo, who has entered the waiting room?
Council is part of your teams, one of your teams.
It's not one of...
Justice Teron Tokozo is my clerk. Tokozo Sobikwa.
Yes, there's no surname, Justice Mhlantla. Perhaps, we'll communicate with the clerks. Thank you.
All right, thank you. Yes, thank you, Justice Teron. Thanks, Justice Mhlantla. Mr. Shangisa?
Thank you, Justice Madlanga and the justices. The issue that arises in the present application for leave to appeal is a very narrow one. As the justices will have seen from the papers, it concerns what is known as the notified maximum demand, which is really the jargon used in the electricity supply industry for an agreement between Eskom and the municipalities with regards to the amount of electricity that is required by the municipality as Eskom's customer, subject, of course, to the availability of such electricity, the capacity of the network, and the payment for the upgrades to accommodate any increase in the NMD load that is supplied by Eskom to the municipalities. So I do not propose to rehash what we have dealt with in our heads of argument. I do, however, wish to deal with at least 4 main topics which relate to this application for leave to appeal. In the first instance, I wish to deal with the nature of the order granted by the High Court and upheld by the SCA, because it is quite important in the present proceedings. Secondly, I propose to deal with the issue of what the applicants in the High Court, the respondents here, characterized as insufficient supply of electricity by Eskom. Put differently, the question that I propose to deal with relates to whether or not Eskom was required to supply more electricity load than it already did in the circumstances of the present matter. The third topic I propose to address concerns the effects of illegal connections to the grid. It's a very important aspect which we submit did not arise in the authorities that are relied upon by the respondents in their contention that they are entitled to more electricity than is currently contracted for. And of course, the last topic that I intend dealing with relates to the appropriate remedy available to the respondents that they ought to have availed themselves of. Now, at the very outset, when dealing with the issue at hand, it is important to emphasize that this is a matter where Eskom continues to supply both municipalities, the Lekwa municipality and the Nwate municipality. It is not an instance such as was the case in other previous matters where Eskom was criticized for interrupting the supply to the entire municipality. It, however, stands on a completely different footing from those matters because here, Eskom supplies Lekwa municipality with the amount of NMD that is required. In this instance, it is 55 MVA as set out in the NMD agreement between Eskom and the Lekwa municipality. In regard to the Nwate municipality, Eskom supplies the required 21,000 VA of electricity as required by the municipality. But the justices would have noticed that the main nub of the complaints by the respondents is that the electricity they receive is woefully inadequate and does not accommodate their needs. They then approached the High Court and obtained the orders that were granted by Justice Miller. The main thrust of those orders were that the court compelled Eskom to increase the electricity supplies to the loads that were previously supplied before its decision to strictly supply in accordance with the agreed NMD in respect of both municipalities. Now, in our submission, the nature of the order granted by the High Court and as upheld by the SCA simply entails that despite the agreement between Eskom and the two municipalities, the court compelled Eskom to supply over and above the agreed load of electricity. That, of course, has a number of difficulties which are raised by Eskom in its papers. Those difficulties arise primarily because if one has proper regard to the nature of the NMD, it is a means by which a licensee such as Eskom is able to plan for the amount of electricity it has to generate so that it could appropriately apportion or supply to the municipalities who are its customers as requested in terms of the NMD agreement. Now, where there is an excess in the usage of electricity by a municipality, the so-called NMD rules, which are issued by the regulator, NERSA, prohibit those, and in some instances, it imposes the sanctions in the form of penalties that are levied so as to against the municipality which exceeds its allocated NMD, so as to dissuade the municipalities from exceeding their allocated loads. The main difficulty that Eskom has expressed throughout the proceedings in the High Court, as well as in the SCA, concerns the effect of the order insofar as it compels it to supply more than is required. The starting point in this regard is that when one properly looks at the NMD agreement between Eskom and the municipalities, it entails that in those instances where increases are sought, there must be an upgrade to the electricity network and the infrastructure so that it accommodates the increase that has been now sought and supplied to the municipality. The difficulty with the order granted in this matter is that it was issued without such required contemporaneous upgrades to the electricity network. Of course, this has dire consequences, both for Eskom, the residents, and the municipality itself, because any overload to the system may result in explosion of the transformers, because the transformers can only accommodate the amount of electricity load that is supplied at a particular time. It is not geared to accommodate more load than is contracted for. That is so because in the event of an increase being required by the municipality, there has to be the necessary upgrade to the infrastructure and ensure that the network is configured to accommodate the further and the excess increases of the load.
At that point, Mr. Changisa, colleagues will now begin putting questions to you. Please continue.
Mr. Shangisa. Mr.
Yes,
Shangisa.
Justice Chip.
You've said in your submissions that Eskom was previously supplying more electricity than the NMD.
Yes, Justice.
And in your heads, you have said that the respondents should have referred this matter to NERSA, and you criticize them for the failure to do so.
Indeed, Justice Chief.
So my first question is, why did you not refer it to NERSA? Number one. Second one, I'm sure you've seen paragraph 61 to 63 of the judgment in Resilient, the SCA judgment, concerning the provisions of section 40 of the Intergovernmental Framework Act. Why did you not invoke it? Because remember, here you had supplied more electricity than the NMD. And you then decided to reduce it because of the fact that you are not getting payment in spite of undertakings from the municipalities. So why did you not yourself invoke the provisions provided for in section 40 and also the NERSA point?
Yes, thank you, Justice Chikri. The answer is really twofold. Insofar as approaching NERSA is concerned, justices would have seen that in instances where Eskom is supplying electricity in accordance with the NMD, it is really either the municipality or the residents that are aggrieved. And so the approach adopted by Eskom was simply that in that event, it is open to an aggrieved party to approach NERSA in accordance with Section 30 of the Electricity Regulation Act, because that is an available internal remedy to an aggrieved party. And also, in respect of the license conditions, the transmission license issued by NERSA by Eskom, the internal remedy available to an aggrieved party is to approach NERSA. In other words, this is one of those cases where Eskom continues performing in accordance with its statutory obligations and its license conditions. It is therefore, in those circumstances, open to an aggrieved party to avail itself of whatever internal dispute resolution mechanisms. Now, the second aspect to Justice Chikri's question concerns the question which then arises whether if Eskom's conduct or administrative action is sought to be impugned, is it appropriate for the decision maker whose decision is being impugned to be the one which purportedly avails itself of the internal remedy? We submit that that cannot be the case, certainly not in the circumstances of the present matter, because we are supplying strictly and fully in accordance with the NMD. And in the event there is unhappiness with regards to the amount of load we are supplying, then an aggrieved party should and indeed is enjoined to approach the NERSA. May I refer justices to the Eskom's transmission license because it is quite instructive. It is it appears on volume 9, page 816 is particularly instructive in this regard because it puts paid to what the respondents contend ought to have been done by Eskom. If I may refer at page to page 816, in particular, paragraph 8, it's under the rubric settlement of disputes. 8.1 reads as follows. This is now extracted from Eskom's transmission license. It says, and I quote, the NER, which is the regulator, NERSA, is entitled to settle disputes between the licensee and its customers or prospective customers or any person affected by the operation of this undertaking regarding A, the right to transmit, B, the provisions of the grid code, C, the prices at which services are provided, D, delays or refusal to provide a service by the licensee, and E, any other matter in respect of which the licensee or its consumers requests the NERS to act as a mediator. Then 8.2 is particularly instructive. It says, and I quote, any decision of the NERS, the regulator, on a dispute as contemplated in section 8.1 above is binding on the parties to the dispute. May I perhaps pause here, Justice Chikri, and reflect on the following. Two things. It may well be so that the respondents charge Eskom with the failure to approach the NERSA, a point which Justice Chikri has raised with us. But on the other hand, it is equally true that if one has regard to the settlement of disputes as set out in the transmission license of Eskom, it is equally incumbent upon the respondents, if they are so advised, to approach the NERSA. And in the same vein, it's equally open to the municipalities in the event they are unhappy with Eskom's decision to approach the NERSA. So my answer to the first leg of your question, Justice Chikri, is that whilst we noted the respondents' contention that Eskom ought to have approached the NERSA, it seems to us, with respect, that as aggrieved persons, it was incumbent upon them to do so. In fact, it was open to them to do so. That's the first aspect to Justice Chikri's question. The second aspect, of course, relates to the provisions of Section 40 of the Constitution. Now, we submit, as the justices would have seen, that because this matter involves the NMD, which really deals with the appropriate amount of electricity that should be supplied to a particular customer, it implicates polycentric and, in particular, issues that fall strictly within the province of the regulator, NERSA. That is so because of the technical aspect involved either in quantifying the appropriate amount of electricity involved or in determining if a particular customer is entitled to an increase in circumstances where, such as in the present matter, it has not met its obligations to upgrade the infrastructure, to upgrade and maintain the network, to ensure that there is an increase in the electricity network so that it could accommodate further increases supplied by Eskom. In the absence of that,
Mr. Shangisa, I'm sorry. I'm happy that you're taking me through this extensively. In that process, you saying that this was a polycentric issue. I don't know whether you're going to argue that what arose in Resilient was not a polycentric issue. So just keep that in mind as you're taking me through your response. Because the way I read paragraph 61 to 63 of the SCA judgment in Resilient, it seems to affirmatively say that these kind of issues, it's appropriate for them to be referred, to be resolved through section 41.3 of the IRFA. So you'd have to distinguish why what happened in Resilient was not a polycentric issue and this is a polycentric issue.
Yes, if I may just respond, thank you, Justice Chikri. If I may just respond quickly to Justice's question. There are features of this case that do not at all appear in Resilient. One of those, Justice Chikri, is the very nature of the NMD. It's not the subject of Resilient. Resilient, in contrast, dealt with the issue of the municipal debt and the decision by Eskom to try and extract the payment of that debt by bringing pressure to bear upon the financially delinquent municipalities by terminating the supply of electricity. In other words, in that matter, the issue front and center concerned the non-payment by the municipalities, which resulted in Eskom threatening to entirely withhold its supply of electricity. By contrast, in the present matter, Eskom supplies fully in terms of the NMD agreement as required by the municipality. The only contention relates to whether or not, in circumstances where the municipality has not upgraded the infrastructure does not have the capacity to carry more load than is contracted for, Eskom can be compelled to nonetheless supply more electricity. Also, of particular importance, in Resilient, there were no explosions caused by the overloading of the infrastructure. In this matter, Justice Chikri would have seen that in respect of both municipalities, there were explosions of transformers occasioned by the overloading of the infrastructure because the municipalities were drawing electricity in excess of what was required without making the contemporaneous upgrade to the infrastructure so that it has capacity to carry more load. Those factors in our submission make this matter materially different to resilience. The
but
polycentric,
you will agree, sorry to interrupt
yes,
you, Mr. Shakira. You will agree, though, that the one common feature is the effect of the reduction of Eskom supply, the effect it had on water in the community and the citizens, and that is a common feature between resilient and this matter. And I'm still going to process your submissions, but I don't see how that then, hello, Mr. Shangisa?
Apologies, Justice Chief.
I don't see how that then assists you in resolving the question that I posed to you regarding whether Section 40 should have been invoked or not.
Justice Chikwe, thank you for the question. Let's test the proposition, and because it is also raised by the respondents, it also arose in the SCA judgment. Let's see if it measures up to scrutiny insofar as the issue of the polycentric nature implicated here is concerned. Let's take the Ngwate municipality. It is common cause that in that municipality, Eskom supplies 95% of the required electricity. But, and this is so significant, the 5% that is outstanding is on account of the wastage caused by the explosions that resulted in one of the transformers being out. It's no longer operational, and on account of the explosions. But what really caused the explosions, as far as the common cause facts are concerned, were illegal connections. Now, let's deal with that for a moment. If the matter were to be referred to the IRFA process, one asks the question, wouldn't anyone who's part of that process ask the Ngwate municipality, but why do you have explosions? They would obviously say because they're illegal connections, but they will go further and ask the question, is there no obligation on you in terms of your license conditions, in terms of the agreement you also have with Eskom to ensure that you protect the integrity of your infrastructure, and that where there are illegal connections to your network, you have a positive obligation to remove those? They will say, yes, we have those. Then the question then is, why should that matter go to the executive in terms of the IRFA process instead of the regulator in the event there's a dispute that is set up to precisely deal with such issues? There is explosion, there is 95% of supply. The 5% that is required is lost on account of wastage occasioned by illegal connections. So I will say, Justice Chikwe, this is what really distinguishes this matter from the SCA's Resilient, where the issue centered on the payment of the electricity accounts rather than issues such as the explosion and of the transformers and the failure by the municipality to remove the illegal connections, which resulted in its exceeding of its NMD.
Mr. Shangisa, can I sorry, my sister, sorry.
Just one last question, my brother.
Yes.
What in your submission is the purpose of the whole IRFA process?
Justice Chikli, it is clearly there to ensure that where there are intergovernmental disputes between state organs, those are resolved before resort to court. That is the principal purpose of the IRFA process. But it also sets out, as Justice Chikli is aware, that where the relationship between the state organs is governed by a specific statute, and that statute provides for a dispute resolution mechanism. Parties must first deal with the issue in terms of that specialist, in this case, the Electricity Regulation Act, whose provisions create the regulator, the specialist regulator, and Section 30, and importantly, issues the licenses that contain the obligations of the licensees, such as Eskom and its customers, including the municipalities who are also licensed to distribute and reticulate electricity to the end users. They also bear obligations in terms of their license conditions.
Justice Madlanga, I'm done. Thanks, Justice.
Thank you. Mr. Shangiza, two aspects. The first is related to what my sister just asked you. One of the concerns I have in this case is that government, and I include here provincial, national, and local government in particular, appear to have washed their hands of this dilemma that Eskom finds itself in. Now, Eskom is hard-pressed to supply electricity more than the NMD, because that has implications not only for the local municipalities, but also for the national grid, as I understand it. Is that correct?
That is correct, Justice Majid.
Now, one of the things that you submit in your heads is that the SCA was wrong, and the High Court too, for failing to hold the municipalities accountable. But the applicants counter that. They say you should have instituted a counter application seeking that kind of relief against the municipalities. What do you say about that?
Yes, thank you, Justice Majid. There are instances, in particular, they raise that issue because one of the authorities we rely on is the very recent decision of the SCA in the Litsimeng matter, where the SCA held the municipality accountable and ordered it to pay Eskom whatever is owed. Now, they contend that Litsimeng is not opposite in this matter because here there is no counter application. Now, that is correct. We argued Litsimeng, but the reason there is no counter application in this matter is that it came not only as an agent application, but it dealt with the issue of the NMD. It dealt with that issue in circumstances where Eskom continues to supply fully as required by the NMD agreement. Anything in excess of that, as a matter of law, as we argue in our papers, is illegal. That much is borne out by what the NMD rules themselves set out insofar as the duty to ensure that there is no excess in the amount of electricity that the municipality draws and the penalties that are then levied against the municipality. And secondly, insofar as the holding of the municipalities to account is concerned, that is a remedy in law that which is readily available to the respondents. That is so because on the facts of this matter, they contend that they religiously pay their electricity accounts, but the municipality fails to account for how it uses the collected revenue, and it also fails to pay over to Eskom. That then cries out on those facts. Those facts cry out for a mandamus that ought to be readily available to the respondents. But it's different from what obtained in Resilient, because here we're not suggesting that the form of mandamus should simply be for the respondents to compel the municipalities to pay. But the municipalities must account for how they use public resources. We have set out in our papers the obligations of the municipalities, and their failure to comply or to discharge their obligations ought to result in the respondents holding them to account for that failure and then forcing compliance with their obligations. Now, that is all the more so in this case where Eskom continues, and we keep on harping on this, continues to supply fully in accordance with the agreed load of NMD.
Sorry, may I interrupt you, Mr. Shangisa, in the interest of time? You see, the residents find themselves in a very difficult situation. They pay their accounts. Eskom is supplying electricity above the NMD with concomitant penalties to the municipalities. And then all of a sudden, the supply is reduced to the point where there's a crisis of sewage, raw sewage running into the streets and into the river, and the hospital can't function, etc., etc. So on what basis do you say that they should have held the municipality accountable? This is an urgent application for interim relief pendente lite. Was that not the sensible course for them to adopt where as they say, Eskom is using this argument about exceeding the NMD as leverage to extract payment from the municipality, and they are collateral damage to a very, very severe extent?
Yes, thank you, Justice Majid. When one looks at the facts that are relied on by the respondents in establishing what they characterize as human catastrophe resulting from Eskom's decision to reduce electricity, one would have to similarly look at the common cause facts, including the fact that in 2014, the residents in Wate obtained a court order in terms of which the municipality was compelled to make good on its various statutory and constitutional obligations, including the issues relating to the spillage of raw storage, the issues relating to the dysfunctional infrastructure. All those issues arose before Eskom took its decision. The question we then pose in our papers is, what became of that court order that the residents obtained in 2014, where Eskom was not even party to the proceedings? We know that the residents' complaint, which resulted in the court order of 2014, granted by the High Court in the Free State, were largely centered on precisely the same kind of issues that they now lay at the doorstep of Eskom.
Did you raise this in your answering paper? Sorry, Mr. Shangisa. Did you raise this 2014 judgment and order in your answering papers? The residents say no, and that's why it wasn't an issue.
We raised it, Justice Majid, in our submissions,
but not in the papers.
In the papers, because it was an agent application, we said, first of all, we're not party to the court order that was obtained by the residents. We then said, secondly, at that time, it was not legible. But elsewhere, we dealt with it. If Justice Majid will permit me, can I come back to Justice with an answer to this question?
No,
I
sure.
do appreciate-
They do refer in your heads to paragraph 59 of your heads, and I've seen it there. The only point I'm making is you didn't raise it in the answering affidavit, so they couldn't have. They need not reply to something that wasn't an issue. Correct? It is in your heads. That's.
It is in our heads.
Yes.
Justice, can I make sure? Can I make absolutely sure? I do appreciate that this is what they raise in their papers, that this was not raised as an issue.
Yes,
which
we can get back to it later. I just want to move on. I want to give time to other colleagues. My second and last question is this, and it's a concern that I have that I would ask Mr. Van Eeden as well. The question of sufficient electricity, I think it's clear on our jurisprudence that electricity is part of a basic municipal service right that residents have. But the question of sufficient electricity raises the question that is not really addressed in any of the heads and in the judgments, the question of a minimum core standard. You see, in our law, from Grootboom and Mazibuko, in a long line of cases, this court has pertinently held against imposing a minimum core standard. In other words, that there's a minimum core to the right to water, the right to housing, etc., etc. For example, the right to housing doesn't imply that you have a right to an earth or to a right to a house. But now this question of sufficient electricity in the context of this case, does that not impose a minimum core standard, which I say this court has on various occasions set its face against? How do you see the case?
Thank you, Justice Majid. We did attempt to deal with the issue of sufficient electricity. If I may just refer, Justice Majid, to paragraph 8 of our heads of argument. Perhaps we start at paragraph 7, and we refer to Mazibuko, the authority of this court, which related to the issue of whether or not a state organ in that matter had a duty to provide sufficient water. And we contend that on this authority, because Eskom is supplying what it can, given its capacity and the demands on the grid, the contention by the respondents that they are entitled to more electricity than is already provided for because they are entitled to sufficient electricity runs counter to the authority of this court in Mazibuko. We do deal with it, Justice Majid, and we say at paragraph 9, after having quoted what this court said in Mazibuko, we say properly distilled, the true import of Mazibuko disposes of the question as to whether or not the municipalities were entitled to receive sufficient electricity from Eskom, and that the principles enunciated in Mazibuko are equally opposite in the present matter. And then we go on to explain the reasons why, because we are supplying and other factors that we enumerate in our heads of argument. But I do agree with Justice Majid's observation and proposition that this court has pertinently dealt with this issue. And because of the competing demands on the resources of state organs that have obligations to provide services, the issue of the minimum core demand is implicated.
Except,
So
Mr. Sangisa, sorry, on the facts of this case, sorry to interrupt you, on the facts of this case, the problem is this. It seems that on the common cause facts, I'm not sure if it's common cause, but you'll correct me, but it seems on the common cause facts, the NMD is not sufficient in the instance of both municipalities. And they've applied more than once for an increase, but the requests are denied because they must first settle the outstanding debt. So there's a catch-22 for the residents, for the municipality, and then indirectly for the residents. How do you resolve this?
Well, Justice Majid, I have to go back to what I said to Justice Chikri, and I think it's quite a legitimate concern, but we answer it by referring to the peculiar facts of this matter, which implicate the issue of illegal connections. If you look at both municipalities, they have a problem with regards to their failure to ensure the integrity of their electricity network. And in both municipalities, there have been instances of illegal connections. There were explosions which resulted in the municipalities drawing electricity in excess of what they contracted for. Now, what we submit is that in a circumstance such as that, it is the obligation with respect of the municipalities to ensure that they make good on their own duties insofar as the securing of the network is concerned, ensuring that there are no illegal connections, and that where these occur, they are removed. But of course, the frustrating part, which has been expressed both by ourselves and our colleagues for the respondents, is that unlike in Resilient, where municipalities entered the fray and put up some factual averments explaining to the court their circumstances, here the municipalities have remained supine. They have been very inactive. They have not bothered to enter the fray and enlighten us as to their circumstances. That is the difficulty we all find ourselves in. As a result, we submit that on the facts such as we have, the issue of excess of the NMD is caused by poor management by municipalities of their network, which manifests itself in the illegal connections and the explosions. There is no countervailing argument to what we suggest, and we cannot speculate that it's because they are dysfunctional and they are delinquents. Whilst that may be so, but we say if they were to take steps to ensure that this does not occur, there will be no exceedance of the NMD.
Yes, thank you, Mrs. Shangisa. Thank you, Justice Malanga.
Mr. Shangisa.
Thank you, Justice Machi. Yes,
Mr.
Justice
Shangisa, does Eskom still maintain that its decision to reduce electricity supply was related to the contract and does not constitute an administrative action?
Thank you, Justice Theron. At the time the papers were drafted, that appeared to have been the case. That was what was raised by my predecessors in the matter, probably because this was an urgent application with extremely truncated timeframes. But Justice Theron would have seen that with the passage of time, we completely disavow that submission, because the decision of the SCA in Resilient makes it quite plain that the decision to reduce or terminate electricity constitutes administrative action that is susceptible to review under PAJA. So we do not persist with that argument.
Would it not follow then that the residents would have a prima facie right to procedural fairness? And related to that, did Eskom comply with that?
Thank you, Justice Theron. The question of the prima facie right, yes, arises, but we first of all deal with it on the basis that when it comes to the invocation of the PAJA, the first port of call that the residents ought to have availed themselves of is was to approach NERSA in terms of Section 30 of the ERA and in terms of Eskom's license conditions and the municipality's license conditions.
Yes, since we've gone to Section 30, let's not forget my question because it hasn't yet been answered, but we can talk about Section 30. If we look at resilient, paragraph 84, the SCA appears to suggest that where there's an interruption of bulk electricity supply, Section 30 is not relevant. What do you say to that?
We say that this matter stands on a different footing because here one is dealing with an instance where there is continuous supply by Eskom. There is, in the proper sense of the word, no termination of supply. It's just that for the factors that I have mentioned.
But resilient doesn't talk about termination, Mr. Shangisa. It talks about the interruption.
Yes.
Would a reduction not amount to an interruption?
It is a form of interruption, Justice Theron, but one that stands on a different footing from the form of interruption that obtained in resilient. Justice will recall that in resilient, the form of interruption.
Sorry to interrupt you, Mr. Shangisa. In resilient, the ACA says where there is an interruption. It didn't say where there is a particular type of interruption. It said where there is an interruption. Section 30 would not apply, but Section 40 and 41 may.
It says that
it relates to your submission that the respondents should have proceeded in terms of Section 30 of the Electricity Regulations Act. It seems that resilient goes against that submission that you made.
We distinguish, Justice Theron, with respect between different kinds of interruptions. And as I pointed out earlier, the kind of interruption implicated in resilient concerned Eskom's decision to completely terminate the supply of electricity. Now, it did not only deal with the form of interruption such as we have here and which we suggest is legitimate and falls outside the prescription or the prohibition contemplated in resilient, where Eskom supplies fully, but the municipalities exceed their NMD. The perfect example to illustrate the point will be load shedding, by way of example. And we make the point that it's a legitimate form of interruption that is meant to protect the grid. So it doesn't fall within the prohibition contemplated by the SCA with respect in its decision. If even the word interruption is broad enough, but the error itself refers to, in 21.5, to termination and reduction in particular.
So, Mr. Shangisa, do you maintain that Eskom has made a case out for legitimate interruption?
I do, with respect, Justice Theron, because it supplies continuously, but for reasons that are not attributable to it, the municipalities require more electricity than is contracted for. And those reasons include the illegal connections and the network of the municipality that requires contemporaneous upgrade if any increase is to be supplied to the municipalities.
Now, if we go back to, even if it is a legitimate interruption, it still constitutes an administrative decision. Is that right?
It certainly does, yes.
What steps did Eskom then take so that its decision would not adversely affect or at least give the residents notice of its decision?
In our papers, we refer to the media notice that Eskom issued. The media notice is at volume I think it's volume 6. I will give the reference in a moment, Justice Theron. But of course, it is a subject of debate between ourselves and our colleagues who contend that the residents, well, at least their clients, were not aware of that notice. So to that extent...
That would be my next question, Mr. Shangisa. Was that notice sufficient?
To that extent, it's being called into question. I accept that. But insofar as Justice Theron's question is concerned, I can do no better than refer to that notice. Whether it is sufficient, well, they say it's not sufficient. We say it was public enough to attract the attention of the residents, but it is a subject of debate nonetheless.
My last question, Mr. Shangisa, relates to whether the residents would have had a legitimate expectation that despite the agreement between Eskom and the municipality, that steps, or it relates to that steps would be taken by Eskom to notify them of its decision and also to try and minimize whatever damages can result from that decision. Would you accept that?
As a matter of principle,
would you accept that Eskom was entitled to reduce the supply without consulting with the residents? And this goes a bit further than the notice in the media.
Justice Theron, as a matter of principle, we submit that all Eskom was required to do, and it did, was issue the public notice that it did. Of course, it is open to the court to determine its sufficiency or adequacy, and it did that. And also it informed the municipality of its decision, as amply illustrated by the flurry of correspondence between itself and both municipalities. I can put it no higher than that, Justice Theron.
Yes. And I know Justice Colopin is waiting in the wings, and I know I did say that was my last question. What would your comment be on how the Supreme Court of Appeal dealt with Eskom's allegations regarding the legitimate interruption, where Eskom says we're reducing supply because the grid has not got the capacity to take it? What would your brief submissions be on the way the SCA dealt with and perhaps rejected that argument? Was there a basis for it, for the SCA to reject that argument or version that was put up by Eskom?
Thank you, Justice Theron. This is really an important question because it goes to the heart of our application for leave to appeal. Justices would have seen that the SCA simply said the distinction we sought to draw was artificial. Of course, we take a different view. We don't, with respect, think that was correct. We say so because even if one looks at the resilient High Court now, we refer to what Justice van der Linde said, although it was an obiter dictum, but it's of persuasive force because it sets out the law correctly, where he says the kind of interruption, and I'm paraphrasing, that is being interdicted in that matter was based on the facts that were peculiar in that matter. So the test is a fact-driven one. He then says, which is important, and it answers Justice Theron's question and disposes in our submission of the SCA's finding that our distinction was artificial. Justice van der Linde then proceeded to say Eskom would be entitled to avail itself of a form of interruption that was legitimate. The reference is, of course, in our heads of argument, and we submit with respect that if one deals with different forms of interruptions, one has to look at the peculiar facts of each case. We also rely on the other judgment of the High Court in Gauteng, in the local division of Justice Van Oosten. It's also in our heads of argument where we enumerated different forms of interruptions, including those that we say are legitimate. And among those is the reduction in terms of the NMD. We say it's perfectly legitimate to the extent that it protects the grid and protects the network, the electricity network infrastructure. If one doesn't do that, the adverse consequences such as the explosions result. So it is to that extent legitimate, in the same way as load shedding is legitimate insofar as it protects the grid from collapsing if it is not reduced. So,
and this is really finally, if you look at paragraph 2 of the SCA judgment at page 685 in volume 7, it says that Eskom took the decision to reduce its bulk electricity supply, and it sets out a number of reasons. And the one it says, as a result of the municipality's failure to honor their payment obligations to Eskom. Is that correct, Mr. Shangisa?
Justice Theron, yes, that is correct. It's lifted from one of the answering papers of Eskom, but it's important to also emphasize that if one looks at Eskom's papers as a whole, the golden thread that runs through its defense concerns the capacity of the infrastructure to accommodate more electricity than is contracted for.
Yes, but so I have a difficulty with that, Mr. Shangisa. If that is correct, then this falls under resilient interruption.
Before you respond, Mr. Shangisa, the 1 hour is up. I know colleagues have been engaging you throughout, but do you feel that there are aspects of your argument that you are yet to canvass, or do you feel that you've touched on everything? Please don't forget what the question was.
Yes, there is one aspect that I would like to deal with very briefly, because it sums up.
How much time do you want for that to do that?
Certainly less than 5 minutes, Justice Madam.
All right, I'll give you that 5 minutes once all my colleagues have their questions to you. So we won't start running now, the 5 minutes. Please respond to my sister Justice Theron's question.
Yes, Justice Theron, as I pointed out, the question of non-payment is one of a number of factors, but it's not the main factor. If one looks
at Mr. Shangisa,
yes,
once it's one of the factors, doesn't that bring us into a resilient interruption, resilient type interruption?
No, Justice Theron, because it is not the singular cause of Eskom's decision. One has to look at what occasions the interruptions. It is the illegal connections. It is the municipality's failure to maintain their infrastructure. If they discharge their obligations insofar as those are concerned, then there will be no questions raised. But importantly, Eskom continues to supply in this matter, and we submit that that very fact places this matter on a completely and vastly different footing.
Thank you, Mr. Shangisa.
Thank you, Justice Theron.
Mr. Shangisa, if my brother Justice Colopin doesn't wish to go first.
You can proceed, Justice.
No, please, you go first. I wasn't sure if you still had a question. Please proceed.
Thank you. Thank you. Mr. Shangisa, this is a very important case and
yes.
Not an easy case, because it doesn't only have implications for the residents' associations before us, but for perhaps all of South Africa. And I want to understand the debate between whether IRFA is applicable or the Electricity Regulation Act. As I read the Electricity Regulation Act, it is described as the national regulatory framework for the electricity supply industry. Section 2 of the Act says that the Act is about the interests and needs of present and future electricity customers and end users are safeguarded, given issues of efficacy, etc. And then in Section 3, it describes NERSA as the custodian and the enforcer of the regulatory framework. So that's how I understand ERA and any disputes that might arise from it. In addition, the provisions of Section 16 of the Act could be interpreted to say that Eskom is established as a licensee that is entitled to a return on its license activities and to get the full cost. On the other hand, we have residents who are paying and who say they are deprived of electricity. But it seems to me that the order that Eskom is required to implement is an order to supply electricity at levels in excess of the NMD to municipalities that the court has accepted are recalcitrant and dysfunctional and may not have the means or the capacity to perhaps even receive the electricity, to look after the infrastructure and to take care of illegal connections. So in the bigger scheme of things as described in the ERA, how does this impact on then the sustainability of a licensee such as Eskom in the light of an order to supply without any conditions? And yeah.
Thank you, Justice Colopin. That really sums up what we set out in our papers, because we say the order as it stands has deleterious effect on Eskom, and the result being it may even lead to collapse of Eskom. But of particular importance concerns whether that order could just be implemented without requiring the municipalities to meet their end of the bargain. And their end of the bargain in this instance entail upgrading the infrastructure so that the network is able to accommodate electricity in excess of what is contracted for, ensure that illegal connections are removed entirely. In the absence of that, we already know, and this is not speculative conjecture, it arises precisely from the facts of this matter, that where electricity supply is in excess of what is already contracted for, and in excess of what the transformers and the network can carry, has the capacity to carry, or the network is configured for, this will inevitably result in explosions. We're sitting with transformers in this case, which have exploded, once again leading to the municipalities having to seek more electricity than they have requested in terms of the NMD. That is the first point. The second point concerns the adverse effect that has on Eskom, because then it becomes something akin to a bottomless pit that is required to continuously supply electricity without any proper planning outside the framework of the era, which makes plain what is required of Eskom as a licensee, if it is to realize, firstly, some gains, financial gains out of supplying electricity, if it is to have a means of funding its own generation capacity, etc. I agree, Justice Kolapen, with your observations. They are quite correct, and they go to the very heart of why the order of the High Court cannot stand in circumstances such as the present.
I'm not saying it can't stand, but my second question is that
yes,
there's a recognition that the return to figures, the NMD figures, may well have catastrophic consequences for residents, for vulnerable people. As an organ of state, and surely notwithstanding the conduct of the municipality, what would you say in the light of those likely consequences? Would the constitutional obligations of Eskom be, given that it is the only source of electricity to the respondents? Surely it cannot simply say, because we have a recalcitrant municipality, we're sympathetic to those consequences, but we can't do anything about it. Surely it must be able to do something more than that, but perhaps less than what the municipality seeks. Is there some view you have on that issue?
Yes, Justice Kolapen, thank you for the question. One has to also look at another defense raised by Eskom, which concerns its own capacity to meet the demands that are made in excess of what it is already supplying. The papers, Eskom's papers, are replete with instances where it consistently points out that it doesn't have capacity to supply more than is required anymore. It says so precisely because the municipalities, as Justice has pointed out, are not discharging their obligations. But at some stage, Eskom was able to supply in excess of what was demanded or required by the municipalities. But it says because the infrastructure has become so dilapidated, it has become so aged, and there are these explosions, they have financial consequences on Eskom itself. It is for this reason that it says the best available remedy for the respondents would have been to approach the NERSA. One of the, as Justice Kolapen is aware, one of the reliefs that NERSA may grant in the circumstances would be the suspension of the municipality's license, its revocation, etc. Those are all in the all part of the license conditions of the municipalities. So NERSA can come to the aid of the residents. Of course, we have sympathy for the residents' plight. We say in our papers, their interests are not mutually destructive to Eskom's interests. They are quite reconcilable because both parties are victims of municipalities' delinquency. But we try to find an appropriate middle ground that we say ought to have been resorted to in this matter. And as Justice Kolapen has correctly pointed out, we say the remedy can only be sourced in the era because of the issues that we have raised here relating to the capacity of the municipalities to carry more excess than is contracted for. Eskom's own capacity, if it is compelled to comply with this order, is also implicated.
Thank you, Mr. Shingisa.
Thank you, Justice Kolapen.
Mr. Shangisa, I have, I'm afraid, 3 questions for you, but I think in the interest of time, if you would try and be as brief and to the point as you can, simply because time runs against us. My sister Justice Theron has pointed you to paragraph 84 of the SCA judgment in Resilient, where interruptions were said not to fall under Section 30 because that deals with disputes between licensees. But could I have your submission in respect of Section 31B of the Electricity Regulation Act? Because that seems to contemplate a class of disputes as between end users and licensees, which doesn't appear to have attracted the attention of the SCA.
Thank you, Justice Unterholter. That is really, with respect, the nub of the matter, insofar as the internal remedy is concerned. If one looks
well,
at
just to be clear, do you say that the SCA has made an error of law?
Absolutely, Justice Unterholter, which explains why we harp on the era as an applicable statute that ought to have been utilized in the context of this matter.
Well,
and Section 31.
Yes, assuming that is correct, that in fact this is a class of dispute that is that can be brought under Section 31B, where an urgent application is made by residents, because they say that there are catastrophic conditions in their area as a result of what the municipality is failing to do, and Eskom, they say too, is it sufficient to say, well, you can go to NERSA? Surely, where in urgent circumstances, you can approach a court. The question is whether the relief that they're seeking is the competent relief, but surely you can get interim relief pending an approach to NERSA.
If one looks at the papers, Eskom had taken issue with the agency, not because we are insensitive to the plight of the residents, but simply because of the common cause facts. We point out that all the facts that are raised concerning the dysfunctionality of the municipality date back to 2014. The issue of sewage spillage, the issue of spillage to the Val Dam, the issue of dysfunctional infrastructure date back to 2014, which resulted in the court order being
yes,
granted.
I mean, I think we all appreciate that. I'm sorry to interrupt you, but I think we all appreciate this has a long history. My question, and again, very briefly, if you could, is one about forums. Can you not go to the High Court to seek some urgent interim relief, even if ultimately you have to refer the dispute to NERSA?
It then, thank you, Justice Unterholter. You can, but subject to one qualification. It then depends on the nature of the order that you obtain, because it was not simply a question of obtaining an interim interdict. The order goes above that, over and above that. It goes beyond that, because it requires Eskom first to supply continuous electricity to the levels it did before its decision in terms of the NMD, and to provide a ring feed or a backup in the event there are interruptions. In other words, these two municipalities, if one properly construe this order, are then entitled to continuous supply, uninterrupted supply of electricity. And this has resulted with respect to what we point out too, that even if the form of interruption is not on account of the NMD, is on account of load shedding, on a plain reading of this order, they are entitled to go to court, as they did in 2021 last year in June, and approach the court for contempt proceedings, because yes, there was some form of interruption. So that is the long and the short.
Yes,
of
I think I have your submission there. Then can I ask you a second question, which is relates to some matter raised by Justice Majid. There seems to be an assumption in a number of the cases that we've been referred to that Eskom has a constitutional duty to supply electricity to residents in the position of the respondents' associations here, or at least their members. And I'm trying to understand what the source of that constitutional obligation is. Because Joseph's case deals with the obligations of municipalities, which are rooted in the constitutional obligations of a sphere of government. But where does the constitutional duty of Eskom to supply everyone, and if so, to what level, where does that derive from?
It certainly doesn't derive from the Constitution itself, because if one has proper regard to our papers, we say that the obligations with which Eskom is saddled repose in the municipalities. We then refer to quite a number of statutes. Well, first, the starting point is, of course, the Constitution, which explicitly vests the municipalities with the duty to supply electricity.
I think that's well established. I think that the problem for us is this, where the municipalities shirk their constitutional obligations, as has happened here and repeatedly happens everywhere. Does Eskom thereby have no further constitutional obligations of supply where it's a monopoly provider? And isn't that quite a radical conclusion to come to? Because you point the finger, not without some justification, at the municipalities, but this case is about Eskom's obligations. So the question seems to arise fairly clearly: what are Eskom's constitutional or statutory duties to the residents, as opposed to what are the municipalities' obligations?
Yes, Justice Unterholter, I can put it no higher than that. There is, of course, a statutory duty on the part of Eskom to provide universal electrification in the Republic. It complies with that duty, in answering your question, Justice Unterholter, to the extent that it continues in this matter to supply both municipalities with electricity. Now, the structural and institutional problems experienced by the municipalities with respect cannot be settled or placed at the doorstep of Eskom. It is in that respect we submit that the regulator ought to play a role insofar as there are aggrieved parties whose rights are being infringed by the municipalities.
So if I may put it this way, is your submission, to the extent that Eskom has statutory and possibly even constitutional duties, you're fulfilling them by providing to the level of the NDM?
That is correct, Justice Unterholter. And ideally, if there were no illegal connections and if there were no explosions on the municipalities' infrastructure and transformers, the residents wouldn't be unhappy with Eskom. That tells us then that the municipalities are first and foremost responsible for what happens to their network and the shortfall that is experienced by the residents.
My last question, and I'm sorry, I need to ask you this because it's a question I want to take up with Mr. van Eerden, but if you would refer to the Intergovernmental Relations Framework Act, my question is whether Eskom is in fact an organ of state as defined in that act and its reference to the Constitution, because the concept in this statute is of an organ of state within a sphere of government. What sphere of government, if any, is Eskom part of?
Notionally, Justice Unterholter, it will be national government. but it's not a government department properly defined.
Well, my question is, does the Intergovernmental Relations Framework Act actually apply to Eskom at all?
To the extent that it is a state organ, it does. It does apply.
You see, my question is that there seems to be a difference between organs of state within national spheres of government and organs of state that are state-owned enterprises,
yes,
which may or may not fall within national government. They're a unique species of public entity. That certainly government is its shareholder. Government extensively regulates organs of state such as Eskom, but is it part of national government? That's the question I would seek some assistance on.
No, it is not part of the national government in that sense contemplated in your question, Justice Unterholter. I think Justice Kolapen pointed out what we also raised in our papers, that if one looks at the ERA, which is the governing statute which governs the supply of electricity, it contemplates that Eskom would fund its own projects. It will it will make some profits out of its supply of electricity and so on and so forth. So it doesn't get budgets such as one would if one were a national government or part of the national government as contemplated in your question, Justice Unterholter.
Yes, thank you. Thank you, Justice Madlanga.
Mr. Shangisa?
Yes, Justice Matobo.
I just have one or two questions, depending on your answers. There may or there may not be follow-up. The NMD supply levels,
yes,
are, according to the SCA, 13 or 14 years outdated. And it would seem to me, and tell me if I'm right, that when you take the situation that obtains back then, at that time, it could meet the requirements of the population. You put the point that because of illegal connections, that is where the problem is. Let's put that aside. More than 10 years ago, when you talk about population explosion, our country has increased. And can you say as Eskom that because of the systems that was 20 or 15 years ago can still sustain the supply of electricity in 2021 or 2022? Surely not. Putting aside the electrical, the izinyoga, the legal connections, as you want to put it. And two, Eskom realized in the papers that there are problems relating to the supply. That is, each time when the municipality asks for an increase, there would be an increase subject to those penalties that will be levied against the municipality for the increase. The only time, or what broke the camel's back, is when the municipalities were unable to pay Eskom. I do not understand, neither have I seen the Eskom case to be saying that throughout we have been complaining to the municipality that we cannot meet the increase. What comes out in the fore is, once you stop paying, we raise the issue that we cannot cope. So if you look at the bona fides of Eskom, and subject to what you are saying about the infrastructure and the network, is Eskom in its efforts to resist the case of the ratepayers a genuine one or not? Or is it about money? Thank you.
Thank you, Justice Matopo. May I start at the tail end of your two-pronged questions? The last aspect concerns Eskom's bona fides. We submit that on the facts of this matter, Eskom's opposition is quite bona fide, it's quite genuine. It's amply illustrated by it raises issues of its own capacity to supply more than is required. We must remember, Justice Matopo, that there are also issues of principles implicated here. It's not good enough to say these municipalities, these two municipalities are unable to pay. But what are the broader implications given the competing demands, the quite exacting demands on Eskom's national grid? It doesn't have a bottomless pit from which it draws electricity. It says its capacity is limited. It therefore requires resources to plan properly for the generation and for the supply of electricity. And that much is governed by the framework of the NMD. So to that extent, Justice Matopo, I will submit that it is quite genuine in its opposition, given its own limited resources. The first question concerns the population explosion. Of course, I readily acknowledge, Justice Matopo, that logically speaking, it goes without saying that given the population explosion over the years, there ought to be some increases because of the demands on the municipality's own grid. But our submission is different. We say that in light of that, it is incumbent upon municipalities to ensure that they comply with their obligations to maintain the infrastructure, upgrade the infrastructure, because we don't have resources to do so in respect of all the dysfunctional municipalities. It places an onerous obligation on Eskom to expect of it to do what the legislation governing the municipalities and the license conditions of the municipalities enjoin the municipalities to do. So it's quite frankly
allow me to interrupt you. And if I interrupt you, I would interrupt you and take you back to the very first question you were asked at the hearing on this matter by my sister Justice Chitke. Eskom, as at the time when the residents made the request for an increase in the NMD levels, at that time, Eskom knew about its capabilities. In other words, it was asked to do something that it could not sustain, number one. And realizing that you are asking the impossible from a party, there were mechanisms or avenues available to Eskom to go to the big brother who's the regulator to say, we are now being asked to do what, in terms of our contractual agreement with the municipalities, we cannot afford or sustain. The municipalities are letting the residents down. They are not paying. And now the blame is laid at our door as the suppliers of electricity. What do we do? And mindful of the fact that all what the residents had to do is to approach the court to say, we have a prima facie right, though open to some doubt, that we're entitled to constant and adequate supply of electricity. The actions of Eskom interferes with that right. And if it does, then we're entitled to the remedy. And they went ahead and obtained the remedy. We can debate the order of the High Court, which has problematic ramification, right? But the fact of the matter is they had that right to approach the court, and rightly so, they obtained the order. Eskom didn't do its share of the bargain. If Eskom had invoked the regulator, number one, if Eskom had brought the municipality into the fray to say, listen, I'm not the only wrongdoer here. You are also part to be blamed. Join the fray. Your problems would have been substantially ameliorated. Thank you.
Thank you, Justice Matopo. Just quickly, the first question relates to Eskom's duty, as I understand it, to approach the regulator. May I perhaps remind the justices that here, on the facts of this matter, we're not dealing with an instance such as was the case in Resilient, where Eskom has interrupted electricity to the municipality. It complies fully in terms of its own contractual obligations, but it is the municipality which triggered the application by the residents because it implemented its own load shedding. And it justified it on the basis that it was on account of Eskom's NMD implementation. Now, remember, in respect of both municipalities, the issue, Justice Matopo, as much as we may have to, for a moment, set aside the issue of illegal connections, but it looms large in this matter because in respect of both municipalities, the wastage is on account of those illegal connections on the municipality's own systems and network and infrastructure. And therefore, it is an issue that the municipalities themselves, as part of their planning, ought to have properly dealt with. I do take the point that in circumstances such as the present, there is an obligation, there are some obligations on Eskom. My retort to that is simply that it discharged those obligations to the extent that it fully supplied both municipalities. If the municipalities failed to keep their side of the bargain towards the end users and the residents, in our submission, that should not be laid at the doorstep of Eskom to the extent that it continues to supply electricity to both municipalities. Of course, Eskom is not an aggrieved party who has to approach the regulator. It discharges its obligation of supplying the municipalities. Any aggrieved party, including the residents, has an obligation to approach the regulator and seek relief for whatever they are unhappy about, insofar as the municipalities are not supplying in accordance with their contractual agreements.
Justice Madanga?
Oh, yes, my sister.
I see that Mr. Shangisa is quiet. I just wanted to wrap up because I'm not sure how Mr. Shangisa responded to my brother Unterholter question that he asked about cooperative governance earlier. I just want to clarify it before Mr. Shangisa goes. Mr. Shangisa, do you accept that Section 41.3 of the Intergovernmental Framework Act and Section 4 is applicable to spheres of government and all organs of state?
Justice Chikwe, the leading authority insofar as Eskom's obligations are concerned is Resilient, and Resilient says Eskom has an obligation to invoke or to avail itself of the Intergovernmental Relations Act. So yes, that is so.
And you agree that the Constitution and the Intergovernmental Framework Act applies to Eskom as well?
It does, yes. There's no other authority than Resilient on that score.
No, I'm asking about the acts, Mr. Shangisa. I know that's what Resilient said, but I'm now looking at the provisions of the act and the constitution that it pertains to government and organs of state. That's all.
Yes, it does. Yes.
Thank you.
Thank you, Justice Chief.
Thank you, Mr. Shangisa. Do you still want the 5 minutes or is what you wanted to argue now covered?
Thank you, Justice Madlanga. Just to go back to what Justice Majid asked earlier on, there was a reference that was outstanding in respect of the 2014 court order that was granted in favor of the residents. One will find it at volume 2, pages 175 to 177, where Eskom deals with the effects of that court order that was granted to the residents by the High Court in the Free State. So that is the first. And the last aspect, if I may, Justice Madanga, concerns.
Are we now in the 5 minutes?
Yes, absolutely. Thank you. The last aspect that perhaps merits the attention of this court is the effects of and the import of the court order that was granted by the High Court and the SCA upheld. In our papers, we attach and rely on the judgment of the High Court in Gauteng. It's a judgment of Judge Norman Davis, dated the 26th of June, 2021. In particular, if I may refer Justice's attention to volume 9, because this is where the important aspects which in our submission assist Eskom's case are contained. In particular, at page 804 of that judgment, if I may just take the justices through at least 3 paragraphs of that judgment, because they're 2 paragraphs, sorry, because they're quite important in disposing of some of the concerns that have been raised insofar as the obligations of Eskom are concerned. At paragraph 6.4 of the judgment, at page 804, the High Court there in contempt proceedings brought by the residents against Eskom in this matter, Judge Davis had occasion to deal with the import of the order. He said the following, if I may quote 6.4, having regard to prayer 2 of the applicant's notice of motion, namely whether Eskom's imposition of the NMD of 55 MVA pending the appeal should be declared a contravention of the order or not, the nature of the order must be examined. This is so because despite the use of the words interim interdict used by Miller AJ, the order might be final in nature. Then his lordship proceeded to deal with that aspect. But I want to take the justices further to 6.6, paragraph 6.6, where he proceeded and said the following: apart from the view of Miller AJ and the aspect of issue of estoppel, which resulted from him granting leave, the order is objectively sufficiently final in nature to constitute a judgment or order. The only temporal or interlocutory aspect of the order was the duration of its operation. Had there not been an application for leave to appeal or an appeal pending, the order would, for as long as it operated, have resulted in irreversible consequences. Every day that Eskom would have been compelled to render a single MVA over and above 55 MVA would mean that the agreed NMD will be breached or at least be amended by the court. Even though Eskom might have been able to charge for such oversupply, which the municipality in any event does not pay, the extraction of power from the national grid will be irreversible. Even if restoration or return of the electricity might notionally have been possible, it would not be able to cure the reduction of supply needed by Eskom or its other customers. Also, the risk of sending the supply through aged and dilapidated infrastructure will be incurred with every MVA so supplied. The order is not in the form of a pure interdict, but is in the form of a mandamus. Every grain of compliance therewith is final in effect and cannot be reversed by the court accord or even on appeal. I therefore find, as Miller AJ did, that the order is final in effect. As I conclude, Justice Madlanga, of course, this was in the context of contempt proceedings, and the court was examining the nature of the order that was the subject of those proceedings when it found that they were final in effect. It suffices that if one reads what Judge Davis said there, the true import of the order was that every day that there was an exceedance in the NMD that was supplied by Eskom resulted in adverse consequences for Eskom, and every grain of electricity drawn is irreversible. Now, that is important insofar as one has to deal with the interim order, sorry, Justice Madam, with whether or not the order was interim in nature. And I would invite the justices to have regard to that particular aspect. Thank you, Justice Madlanga and the justices.
Thank you, Mr. Shangisa. Let us take an adjournment, colleagues, to avoid the little fractions. Let's just come back at 12 o'clock, colleagues, please. Court adjourn.
Court will adjourn until 12 o'clock. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone and rejoin with video and sound when the hearing recommences at 12 o'clock. Should you exit, you may use the same link to rejoin the hearing.
Ms. Mbali, I will hear from you.
Justices of the Constitutional Court, all counsel are online.
For the information of those who are following the proceedings, let me again make an announcement I made right at the beginning. I have problems with my camera, so that is why I am not on video. Yes, Mr. Van Eeden.
Thank you, Justice Mhlongo. Joseph's case taught us that the residents in these two matters have a public law right to receive electricity. The municipalities act as a conduit. Eskom has a municipality and it supplies to the municipalities.
Mr. Van Eeden, let me ask this. Forgetting about questions of process, and by process I have in mind issues like, for example, those that were raised by my sister Justice Theron around Paja, for example. There may well be other process-related issues, I do not know. Maybe even cooperative government. I see your hand is up.
Yes, Justice Mhlongo, something went wrong with the sound. Unfortunately, I could not hear your comment.
Let me just check my connection. Let me just check. All right. I'll start right from the beginning. I said, leaving aside the issues of or questions of process, for example, like the question of Paja-related questions or issues related to cooperative government, and possibly whatever other process-related questions. In your view, are there circumstances at all where Eskom would be entitled to, let me use the verb interrupt, to interrupt supply on NMD related reasons?
Thank you, Justice Matlanga. On that issue, we submit that there are two issues that are of importance. We said that Eskom should not interrupt without following due process. And the second issue that goes hand in hand with that is that Eskom should be paid. The intergovernmental respondents, the intergovernmental process that needs to be followed must ensure that Eskom gets paid. And to come specifically to the issue of NMD, if in that process, NERSA or whoever else may govern that procedure should decide that there is a need for a reduction in NMD, that will be dealt with by those government respondents in that process. But what Eskom cannot do with respect is what it did in this matter. It reduced legitimate supply to paying residents without fair notice.
Okay. All right, please continue with your argument, your submission.
Thank you. We make the point that when the residents received the electricity through this conduit, it was completely lawful because they were paying for it. They all paid. There's the exception of illegal connections. It is a problem that plagues municipalities, and the papers demonstrate that the municipalities are giving attention there.
Mr. Van Heerden, sorry to interrupt you. I just have two short questions. The first one relates to the contention that the respondents themselves should have exhausted internal remedies before approaching the court. What is your response to that?
We say with respect that that is not correct. The residents are not party to the contract between Eskom and the municipalities. When this application was launched, NERSA and the other government entities were all cited. So we submit that the residents have, over a long period of time, demonstrated a commitment to resolve these issues. My learned friend made a lot of reference to the 2014 court order in the Ngwati matter. What Eskom did was it simply proceeded to implement the interruptions in the teeth of the dispute with the municipality. The attachments to the founding affidavits demonstrate the efforts that the residents went to notify the other government respondents of the problem. What should have happened then was that the government respondents should have applied the provisions of IRFA. We respectfully disagree with our learned friends where they say that it was not appropriate for Eskom to initiate these proceedings because they are still supplying in terms of the contract. It must have been clear to Eskom that there is a dispute between it and the municipalities. And that dispute, Eskom resolved in its own favor because they invited the two municipalities to increase the NMD. Both municipalities accepted the invitation, and then Eskom turned around and refused it on the basis of non-payment. So that dispute, Eskom should really have referred to NERSA themselves. And then I just want to draw attention to the reference that Eskom relies upon on page 816, paragraph 8. This morning, they, out of the transmission Eskom transmission license quoted paragraph 8 to the effect that any person affected may approach NERSA. We simply point out that that agreement did not form part of the papers before the High Court or the Supreme Court of Appeal. They form part of the application for leave to appeal.
Yes, thank you. The other point relates to the order of the SCA. Eskom says the effect of that order basically is to compel it to actually increase the NMD, and that is going to be against what the rule 583 says. What is your response to that?
Thank you, my lady. The Eskom, the order made by the High Court compels Eskom to do one thing only, and that is to refrain from implementing its decision to reduce to NMD. That is all that Eskom must do. So in the past, they supplied the municipality's need. That need exceeded NMD, and it is because of the decision to reduce it to NMD that the human catastrophe unfolded. So that is what Eskom is not entitled to do, pending the review or perhaps pending the outcome of an intergovernmental dispute. And we submit that must be correct, because the municipalities' needs have been established over a long period of time. It was evident to the two organs of state that the NMD was being exceeded. In fact, the founding affidavit in the Lekwa application contains a notice to the effect that Lekwa states it paid Eskom back in 2014 to improve the capacity and to update the NMD, and that never happened. So we make the submission that the order is correct. The need of the municipality has been established. We know that the infrastructure can supply that need. There is the supply was done in a safe manner for many years. There was one problem in Guati that related to an Eskom transformer that was not properly maintained, and that problem was fixed before the matter came in the SCA. We gave a reference to that in our heads of argument.
Thank you, Justice Malanga.
Mr. Van Eden, can I raise the question with you, please, that I raised earlier with Mr. Shangisa? There's a question of this notion of adequate electricity. Where do you say is the source for Eskom's obligations to supply electricity? And there's a first leg of the question. Second leg is, on what basis can a court find that Eskom, if there is such an obligation, is obliged to supply sufficient electricity? Does that not implicate the jurisprudence of this court setting its face against the minimum core standard over a number of cases from Grootboom and thereafter?
We say respectfully not. The residents are not seeking to be supplied a certain quantity. The need for electricity in those two municipalities was established over a period of time, and Eskom can and did supply that. The safeguard for Eskom is that it can apply the national load shedding regime when it becomes necessary. We do not expect the impossible from Eskom as suggested by our learned friends. The safeguard is built in, and it does not require Eskom to give a continuous supply of sufficient electricity, whatever that word sufficient might mean in the context of these two matters. It is simply a case of going back to what the position was in these two municipalities before Eskom started implementing its decisions to reduce to NMD.
Well, can I ask you this as you give that answer? Eskom says there's a concomitant obligation on a municipality. As Eskom exceeds the NMD, a municipality must ensure that the infrastructure capacity is there, A, and B, that it's maintained. Now, absent such a concomitant compliance with obligation by the municipality, where does that leave Eskom, and where does that leave implications not only for those municipalities and residents, but also for the national grid?
Yes. Justice Majid, we make common cause with Eskom on the issue that they must get paid. We said that already in the founding affidavits. Unfortunately, in these two matters, Eskom saw fit not to introduce counterclaims to protect themselves. And unfortunately also, the problem that arose, the dispute that arose, was not referred to an intergovernmental panel to resolve. But we fully accept that maintenance must be done and that payment must be done. We say that the facts of this matter, however, tells us that Eskom can safely supply both municipalities at the levels pre the interruption.
Well, I'm going to leave that there, but just you answer the second question first. The first question, what do you say is the source of Eskom, not the municipality? What is the source of Eskom's constitutional obligation to supply this electricity? If we accept for the moment it is sufficient electricity that is required.
We respectfully refer this Honourable Court's judgment in Joseph. We say that it is analogous to that position. Eskom has a monopoly, and they supply the municipalities, and there we find a conduit to the citizens who have a public law right to receive electricity. And that is the source of Eskom's obligation.
Well, as you know, Joseph concerned the city of Johannesburg through its entity, City Power. Now, there I think it's quite clear that City Power is part of the organ of state, the municipality's service provider for electricity. But Eskom is different here, isn't it?
Eskom is in a different position. We concede that, but the analogy is very strong because it is in reality the only supplier. So we would submit that it would be, as Joseph said, it'd be artificial to try and separate Eskom from the municipality when it comes to the obligation to supply electricity to the citizens.
You see, just to conclude, as I read the jurisprudence, Mazibuku and Joseph and so on, what it holds is that electricity is a basic right based on a package of services that must be rendered as a right to basic municipal services as it is in the Constitution. That is how I read the cases. But Eskom is not a municipality, so it doesn't render basic municipal services as contemplated in the Constitution. So I'm just finding it difficult to understand how one could draw that analogy from Joseph as you do through to Eskom, which is really an SOE tasked with supplying electricity. We all understand its role and its function, but where does the source of the obligation arise? Doesn't seem to me to be in the Constitution. Is it in the ERA?
It is an SOE, but that is how national government complies with its obligation to supply its citizenry with electricity. But Eskom as a SOE still answers to the Department of Energy. The Minister of Energy was cited, and we in the Framework Act, we also see in Section 9 that any cabinet minister may establish a national intergovernmental forum to promote and facilitate intergovernmental relations for the area in which that minister is responsible. So it is an SOE, but it is an SOE with public obligations.
Well, you haven't really answered the question. Do you say it's in the Constitution or in the ERA or other legislation that's source of that obligation?
It's in the Constitution. It's a basic right to receive it.
Where in the Constitution? As part of the package of municipal obligations.
It serves as the door for the rights enshrined in the Bill of Rights. So
I think what you mean to say, Mr. Van Eeden, sorry, Mr. Van Eeden, I think what you mean to say is it is merely a conduit for the municipal obligation to supply electricity as basic municipal services. Is that what your submission is?
Yes, and the available jurisprudence also tell us that Eskom should not be allowed to interfere with those obligations that the municipalities have towards the citizens.
Yes, thank you. I'll leave it there. Thank you, Justice.
Thank you, Justice.
Sorry, Mr. Van Eeden. Can I proceed, Justice Madlanga? Okay.
Yes, my brother. No, colleagues must just just proceed. Yes, thank you.
Two questions, Mr. Van Eeden. You indicate that the license conditions that was referred to us by Council for Eskom, which appears at page 816 of the papers, were submitted during the course of litigation following the High Court order, and therefore would not have been known to the respondents. Is that how I understand what you said?
Sorry, Justice Colopin, I don't understand your question. Would you please assist me? And
please help me. I think you made reference to the license conditions that would apply to Eskom, and in particular the dispute resolution provisions of those license conditions.
Yes.
And you suggested that sort of emerged quite late in the day. Is that my correct understanding?
Yes.
Okay.
That is correct, because it's only attached in the application for leave to appeal. That's the transmission license. But we submit, Justice Colopin, that for the reasons that we've already advanced, that the obligation to submit the dispute in terms of the IRFA Act was in any event upon Eskom. So even if the residents do have the right to approach a NERSA, it makes no difference.
Okay. All I want you to comment on, Mr. Van Eeden, is that in terms of the ERA, Section 30, subsection 1B that my brother Untitled referred to, NERSA has the obligation where there's a dispute between Eskom and end users, and your clients would fall within the category not of a customer, but of an end user, then there's an obligation on the part of NERSA to refer the matter to a dispute resolution mechanism. Would it not have been appropriate for the respondents you represent to avail themselves of relying on Section 30, subsection 1B leaving aside whether NERSA should have done it on their own, which I think is probably a valid submission as well.
Justice Collipin, we don't dispute that the avenue is open to the citizens to do so, but we say that the section does not saddle it with an obligation on the facts of this matter. The facts of this matter that demonstrate how the government respondents were approached by the citizens to resolve the issue, but that the interruptions nevertheless proceeded. So what the citizens, the position that they found themselves in was that their right to receive electricity was being trampled on. And so they had to come to court to demonstrate their prima facie right. And it's, as I've previously said, it's either pending the outcome of the review that has been instituted in both matters, or the outcome of an intergovernmental problem-solving exercise.
Good. Thank you, Mr. van der Linde. My second question is this, that in the judgment of the SCA upholding the High Court judgment in these proceedings, and paragraph 22 thereof, you don't have to necessarily look at it now. The court dealt with the judgment of Resilient in the Gauteng High Court, and in particular the judgment of van der Linde J. And while it characterized the conduct of Eskom in that context as constituting administrative action, and there is a debate about that, it also went on to deal with what it regarded as the sort of rationality bar, where it basically said that in the light of catastrophic socioeconomic and humanitarian consequences, there would be difficulty in Eskom justifying that as a rational decision. And the SCA seemed to accept that characterization by van der Linde J. My question to you is that, does that not take us along quite a difficult and dangerous path, in the sense that whenever there's a risk of catastrophic social, economic, and human consequences, a government functionary may not act because its conduct would be irrational. And if we apply that standard to the reality of current day South Africa, there is so much that would fall within that category. And what I'm saying is that I'm not suggesting that it doesn't require a humanitarian response, but to elevate the humanitarian response that is required to constituting a constitutional duty is a different matter. And is there not a distinction between the two? Are we not in danger of, as it were, going beyond what is required from a humanitarian basis and converting those into binding constitutional obligations, in this case, on a electricity supplier that, in terms of its own structure and in terms of its own creation, was never intended to have such wide-ranging obligations?
Justice Collin, what we submit was irrational in this matter was to interrupt, to use NMD as leverage to extract payment from two municipalities where Eskom full well knew that they would not be able to pay the arrears. That is where the irrationality comes in. And we submit that, as in that matter and as in Joseph's matter, the decisions to interrupt can never pass that rationality test.
Good. And then just finally from my side, Mr. van Eden, and I traversed this with Mr. Shangisa earlier, the order of the High Court is confirmed by the SCA would require Eskom to continue supplying electricity to two municipalities that are recalcitrant, that are dysfunctional, that are unable to discharge their constitutional obligations. Would you think that in the bigger scheme of the Constitution, that is a proper use of the judicial authority to direct municipalities that can't do their work to be on the receiving end of a scarce benefit of a scarce resource in society, ultimately for the benefit of two residents' associations who may have rights vis-a-vis the municipality. But the upshot of all this litigation is that everything else gets ignored, and a supply line is not to be interrupted so as to ensure that the two respondents do not experience disruption in their affairs, or perhaps even the broader community. Does that fit into the broader constitutional design, you would say?
Justice Colopin, we respectfully say, yes, it does. Eskom should be compelled to continue supplying. But as we've already submitted, they should also be paid. And the two municipalities in issue should really be forced by, if necessary, a court to make sure that they pay. They collect the money from the residents. Everybody is on just about everybody is on prepaid. And we don't know why it is not paid over to Eskom. We have NERSA, we have the two MECs, we have the two premiers, we have the Minister of Energy, and they are all just washing their hands of this enormous problem that have unfolded not only in these two municipalities, but in many other. We make reference to that in our heads of argument, because that was what prompted us to argue in the SCA that the merits of the matter had to be dealt with the SCA rather than to dispose of it on the basis that an interim interdict is not appealable.
Mr. Van Eeden. Oh, I'm sorry, Justice Colopin.
No, sorry.
Mr. Van Eeden, just to look at the Section 30 argument again and internal remedies. Shouldn't the residents have shown exceptional circumstances to bypass Section 30? And if yes, have they done so?
If I may proceed, Justice Strong, from the premise that there was some duty on them to comply with Section 30, I would submit that they did. It took them weeks to establish what was going on. They did not know that Eskom was interrupting on the basis of NMD because they were not notified. And it took considerable investigations to establish that. And then what they did, and the attachments are part of the founding affidavit, wrote to all concerned to try and resolve the dispute. In Guate, it goes back as far as 2014. So they really have attempted to resolve the dispute between the municipality and Eskom. But how much can one expect of residents that are paying for their electricity? How much?
Would your submission be that the attempts to resolve the dispute constitutes exceptional circumstances?
Not to fully comply, then yes.
And is that dealt with in the papers?
What is dealt with at fairly great length is the obligation on the organs of state. I don't recall that the residents claim that they had to comply with Section 30, and in fact, it's out. It was not addressed.
Would that failure to address the question not be fatal, perhaps, to the resident's case?
I would submit not Justice Tron, and besides, NERSA was cited in these proceedings, so they are before court.
That's not the question, Mr. Van Eden, but we leave it there for now. If I can refer you, please, to volume 5, page 485. Paragraph 1.1.3. The answering affidavit filed by Eskom, where it says it is important to note that in terms of capacity constraints, Eskom cannot guarantee the security of supply, and therefore an increase in notified maximum demand is subject to capacity constraints. If a permanent increase in notified maximum demand is subject to capacity constraints, does it not follow that Eskom's temporary provision of electricity above the notified maximum demand is also subject to capacity constraints and can be withdrawn by Eskom if it doesn't have the capacity to supply electricity above the notified maximum demand?
The protection for Eskom is in the national load shedding. We respectfully agree with that. But what happened in this instance is not a reduction because of supply constraints. It's because of non-payment. And may I ask the court to please make a note of is the NERSA rules also on page it's attached in volume 3, page 206, both paragraphs 1 and 2. With the leave of the court, I'll just read the relevant sentence. According to the agreement, Eskom is required to provide the contracted amount of NMD capacity, and the customer must never exceed this capacity. That is what was allowed in the two matters. However, the rules continue. However, customers do exceed their NMDs, and instead of Eskom disconnecting customers for this breach, the NMD penalty is imposed. And that is repeated in paragraph 2. It's also repeated in paragraph 5.1.3. And then also paragraph 5.5.3, page 210, customers who are in arrears should be allowed to upgrade their NMD and or MEC subject to the payment arrangements or arrangements between the licensee and the customer. So if there are capacity constraints, then it must receive attention. And we know that in the instant matter, the refusal to upgrade was linked to non-payment, not to a system-driven capacity shortcoming.
I'm not sure whether it's common cause. I know that is also said in your heads of argument, Mr. Van Eerden, that it was due to non-payment. But and I referred counsel for Eskom to paragraph 2 of the SCA judgment, and where one of the factors set out by the SCA, which the applicant admits, was that the decision, Eskom's decision to reduce supply was partly because of the municipality's failure to pay Eskom. The High Court took a similar view, but it appeared to ignore Eskom's other reasons. And if I can refer you to page 490, paragraph 42 and 43. That is, sorry, in volume 5. Perhaps let's look at paragraph 43. It says, the continued exceedance of the notified maximum demand will cause the transformers to overload and deteriorate even further. This will further damage the system infrastructure as it is not geared to handle the load that is being drawn from it. And it goes on to elaborate. And this is my question, Mr. Van Eeden. Was the High Court, as well as the SCA, entitled to reject that evidence of Eskom, or should Plascon evidence have obliged these courts to accept that averment as true?
So if I may start with the issue of non-payment, and we say in our heads of argument that that was what prompted the reductions, and we do so in paragraph 23 of our heads of argument. And then in footnote 32, we give reference to the letters in both municipalities where Eskom wrote and invited the municipalities to increase their NMD, and where the municipality...
Mr. Van Eeden, I don't think we can proceed on the basis that it was common cause that the decision to interrupt or to provide electricity at a lower level than before, or to provide in accordance with the notified maximum demand, was because of non-payment. Or are you asking this court to proceed on that basis? Because there appears to be disputes of fact between the parties about that. And that is what I'm asking you. Was the High Court and the SCA entitled to proceed simply on the basis that the decision to reduce the supply was because of non-payment?
I submit that they were entitled to proceed on the basis that the interruptions were caused by the non-payment. The correspondence bear that out. I see the paragraph that I'm referring your ladyship to in our heads of argument does not say it's common cause between the parties. I don't know if we said so elsewhere, and Justice Strong, you may be right by saying it's not common cause, but certainly that was the reason that triggered the interruptions. Afterwards, we start reading about capacity problems, but that was not the instance, the problem in the beginning. Nowhere did we read in the beginning you have capacity problems.
Mr. Van Eeden, I'm sorry to interrupt you, but I'm cognizant of the time constraints that we have. Before the High Court and the Supreme Court of Appeal, Eskom put up a version, and part of that is contained in paragraph 43. On what basis was the High Court entitled to reject that version? Where is that dealt with in the judgment of the High Court or the SCA? That the version that was put up by Eskom, that the continued excessive supply of electricity above the notified maximum demand will cause severe problems for the grid and to the infrastructure.
It was found in the history of this matter where Eskom...
Mr. Van Eeden, I'm really sorry, but can you, I'm directing, my question is specific. Where does the High Court or the SCA deal with that and reject that version?
Oh, I beg your pardon. I misunderstood the question for a moment.
Yes, no, perhaps I was not clear, Mr. Van Eerden.
It might be correct that they did not deal with it. If I may just make the submission, it is that the history of the matter reflects that there were no capacity constraints at the time that the interruptions got started, because for years Eskom supplied without a problem.
And where is that dealt with in the judgments, Mr. Van Eerden?
It might also not be dealt with, but it is dealt with in the founding affidavits.
Yes, thank you, Mr. Van Eerden.
Mr. Van Eerden. Mr. Van Eerden, I wonder whether I could take you back to some of the questions that were being asked of you by my brother, Justice Majid. I think it's perfectly clear law that the municipalities bear an obligation to the residents to provide basic services, which include electricity. But I'm still very unclear as to how that municipal obligation is borne by Eskom. How does the obligation which the Constitution and various statutes place upon the municipalities come to be borne by Eskom?
If I may just see if I can find the reference in my heads of argument. We deal with the position in paragraph 21 of our heads of argument. And that explains our submission of the relationship between the residents and Eskom. And we also refer to the Cape Gate and Resilient SCA judgments, where the courts held that Eskom may not conduct itself in such a fashion.
Yes, but Mr. Van Eerden, one of the things that's about the Resilient case is that it assumes that Eskom has this obligation, but it doesn't explain where it comes from. So I take your point. You can do perhaps you rely on Resilient, but I've read Resilient carefully, and I can't find where Resilient finds that Eskom has this obligation which is owed to your clients and particularly the residents.
It might be that the judgment does not deal with it, but our submission is that when you have the organ of state, the sole organ of state with the monopoly supplying municipalities, that is the only structure that the national government has imposed to comply with its obligations to render electricity, that it follows that.
Well, it may be that the municipalities could have certain claims against Eskom as a monopoly provider, but that doesn't give any rights to your clients.
Our rights, we say, we find in Joseph.
No, but Joseph simply explains the obligations of the municipality. It doesn't say, and these obligations are also obligations cast upon providers of electricity to municipalities. Because there's a related problem, Mr. Van Eerden, which perhaps you can assist us with, which is that even if there is some constitutional obligation that Eskom owes, although its source doesn't seem to be evident, and I don't think is in section 27, What about the doctrine of subsidiarity? In other words, Parliament has created a structure under which Eskom's duties of supply are regulated. And that, amongst others, is what the ERA is. So don't your clients have to live within the scheme of what Parliament has provided, which is the ERA? You can't ordinarily invoke a constitutional right where Parliament has given effect to that right through a scheme of legislation.
The problem, Justice Untitled, is that our clients were receiving it. It got taken away by...
No, I understand, but that begs the question, they were receiving something. The question is, did they have a right to receive it from Eskom, with whom they have no contractual link? So the question is, what's the origin of their right as against Eskom? Because that's who you've gone against. You could have gone against the municipalities, but you chose to go against Eskom. So that's why we've got to find a right that your clients have.
The municipality is simply the conduit.
No, but
So-
I've heard you make that argument, but it's not a conduit. The Constitution imposes that obligation on the municipalities. It doesn't say as a means for other entities to discharge their obligations to your client. In other words, to put it simply, the primary obligation rests with the municipalities.
The municipality can only comply with that obligation by recourse to Eskom. It cannot get electricity, and neither can the residents, from any other entity.
No, but the difficulty here is that the municipality has the obligation and the municipality isn't complying with its obligation. So isn't your client's cause of action against the municipality?
The municipality was complying with its obligation to provide the residents with electricity. It simply didn't pay Eskom for it. But we were...
Mr. Van Heerden, I think it's common cause in these proceedings that the municipalities are not doing what they're required, which is, amongst other things, to use the money your ratepayers are paying to the municipality to pay for the electricity from Eskom. So on no account is the municipality doing what it's required to do.
Yes, I'm sorry, Justice Untitled, if I sounded facetious. It's not.
No, I understand.
The point that I'm making is simply this: that until such time as Eskom implemented its decisions to interrupt, the municipalities were supplying the residents. I've agreed.
I know that's factually true, but since your clients have chosen to go against against Eskom, they've got to source that in some right that is owed by Eskom, some obligation that Eskom owes to your clients, and that founds a right that your clients have as against Eskom.
Justice Untitled, they went against the entity that created the crisis. It would have been, it would not have served any purpose to go against the municipalities to restore supply.
Do you accept that if the residents have no rights as against Eskom, public law rights as against Eskom, they've got no basis to bring a review?
No, I don't. The residents have a right to be supplied by the organ of state that has a monopoly through their municipalities.
Now we're going round in circles. You say they have a right to get it from Eskom. We ask you what's the source of that right, and you can't tell us. So if we can't pin down what that right is, do you accept that you wouldn't have a PAJA review?
No, but Eskom's decision is taken, and that is common cause is administrative action. And that impacts on the right of the paying citizens to receive electricity. And the review is founded in that.
Let me ask you, just because I'm aware of time and my colleagues have, I'm sure, questions in addition as well, but can I just take you to the Intergovernmental Relations Framework Act, if you would have that act in front of you. You say that the dispute here obliged Eskom to deal with this matter through and under the auspices of that act. How does the Act and particular Chapter 4 apply in the light of Section 39(1), where there are specific, there's a specific basis for under national legislation that allows for the resolution of these disputes in terms of era?
We made the submission that the Electricity Regulation Act can be used to resolve the dispute. And it might be the manner in which the governmental organs must resolve their dispute.
But then how does the IRFA apply? Because 39(1)(a) says that in circumstances where other legislation provides for the resolution of the dispute, this Chapter 4 doesn't apply.
Well, we submit that this chapter applies.
No, but Mr. Van Eerden, tell me how we're to read 39(1)(a). It says this chapter does not apply to the settlement of specific intergovernmental disputes in respect of which other national legislation provides resolution mechanisms or procedures. So if you accept that ERA does that, then Chapter 4 doesn't apply.
Section 31(a) that I'm being referred to refers to disputes between licensees. That's any dispute. And then,
well, in other words, on the assumption that there is a basis that, as between the municipality and Eskom, they could take this matter to NERSA under ERA, why does Section 39(1) exclude that kind of dispute from the IRFA? Well, perhaps you'd like to give that some thought, because on the face of it, it seems that it does so. Thank you, Justice Madlanga. Those are my questions.
Mr. Van Eerden, just a small point from me on the organ of state issue that was raised with Mr. In Section 2 of IRFA, my understanding is that Eskom is a state-owned entity and not an organ of state, or am I just being semantically engaged?
Justice Mlambo, it was common cause, I think, that it is an organ of state.
Oh, on what basis? Can you tell me on what basis it is an organ of state? Because I've been grappling with this. where the section 2 is clear as to who the act applies to: national, provincial, and local government. Now,
if I can
where
just get
does Eskom fit in there?
I see section 2.1 does not refer to organs of state. It's dealt with in 2.3. And then that must be read, we would submit with section 9.
So are you saying whether Eskom is an state-owned entity which performs no governing responsibilities, it ought to be looked at as part of government in terms of this act?
Well, we would submit that the organ of state, as defined in section 239 of the Constitution, would include Eskom.
That's your submission. Okay, no problem. I won't pursue the point further. Thank you, Justice Madlanga.
Thank you, Justice Malambo.
Mr. Van Eden, I just want to follow up on a question by my brother Untitled. He dealt with you about the source of the obligation in terms of the legislation and the Constitution. But when the SCA commenced its judgment right in the beginning, it says that the central issue in this case, where the High Court was dealing with an urgent interim interdict pendente lite, the central question was whether the residents have a prima facie right. And the court went on to say that the other requirements of an interim interdict wasn't really in dispute. So it seems to me that is a key question. Unless you can pinpoint the source of the right to electricity, then no prima facie right was established. And hence the residents weren't entitled to an interim interdict. That is a key dilemma as I see it on that question.
Justice Majid, that is the submission that we made. We have a public law right in terms of Joseph to receive electricity from Eskom through the municipality, and when we receive it, we do so lawfully because the municipality has that obligation to give, and we pay for it. So we submit that we squarely within the framework established in Joseph.
Yeah.
At that point, Mr. Van Eden, the 1 hour is up. In fact, they were 1 minute beyond. Haven't your issues been covered by your responses to the questions by my colleagues?
Yes, Justice Mdlanga.
Perhaps Justice Majid still has more, but from your perspective.
I'm done. Thank you, Justice Madlanga.
Thank you, my brother. Yes, Mr. President.
Yes, we have nothing further from our side.
Thank you very much. I'll just wait 1 second to see if there are more questions from my colleagues. It looks like there are none. Thank you very much, Mr. Van Eden. Yes, Mr. Shangisa.
Thank you, Justice Madlanga. There is one aspect which our colleague touched on, and in my submission, it merits the consideration of the court. and that is in respect of the NMD rules that our colleague referred to. I just want to refer the court to page 209 of, that's at volume 3, which contains an important aspect of the NMD rules that our colleague sought to rely on. In particular, paragraph 5.4.2 in our submission is of utmost importance because it says, and I quote, "A change in NMD and or MEC is always subject to the availability, to the available capacity." I close the quotes. It suffices merely on reflecting on this aspect that it accords with Eskom's contentions contained both in its papers and in its heads of argument that the issue of its capacity to supply or to increase the NMD ought to have been taken into account by the High Court and certainly by the SCA. And we submit that to the extent that Eskom contended, as set out in its papers, that it did not have sufficient capacity, it did not act unlawfully. Its conduct comports with what is contemplated in paragraph 5.4.2 of the NMD rules that the respondents also rely on. That is the only aspect that I submit warrants serious consideration and the attention of this court. Other than that, unless there are questions from the justices, we have made our submissions in both the written submissions and in the heads of argument. And unless there are questions, that will sum up our submissions for today.
Thank you, Mr. Shangisa. Thank you to both counsel. Judgment is reserved. Court adjourned.
Today's proceedings have concluded. The host will now terminate the meeting.